Andrew Little.
Thank you, Mr Speaker, and malole soifua in this, the Samoan Language Week. It's a pleasure to rise and take a call on this, the third reading of the Victims' Rights Amendment Bill. Mr Speaker, I note, following the Minister's address to the House just now, she referred to at least 3 other pieces of legislation presently going through the House dealing with various different aspects of victims' rights and their place in our justice system. And it does highlight the need, I think, at this point in our history of our criminal justice system for now a cohesive and comprehensive piece of victims' legislation, a comprehensive and properly set out charter of victims' rights, and so that there is one place that victims can go to, and their advocates and their advisors, to understand exactly how it is they can make their voice heard and make their considerations known in the course of the administration of justice by our criminal justice system. As it is, this piece of legislation comprises, 3 bills, is it? 4 bills, to achieve yet more progress, at least incremental anyway, in the place, at least providing for the place of victims in the criminal justice system. And it once again reflects this growing evolution, this growing development of the place of victims, the previously hidden, sometimes even unknown voice and place of victims in our criminal justice system. And it's for that reason, Mr Speaker, we support the bill. It makes improvements. It builds upon the work that was started in the 4th Labor government in 1987 and again in the 5th Labor government in 2002. What I suppose is surprising is that this bill started its life in 2011, and 3 years on we finally get round to passing it. And so this government is in no position to say it accords priority to victims' rights and victims' interests. This is an also-ran piece of legislation, if you like. Close to an election, the government realises it has to do something, and it suddenly puts on the pace. But listen, let's not quibble about it. Let's not be petty about it. This is nevertheless important legislation. And Chris Finlayson QC, the Attorney General, would know all about quibbling and being petty. Because if there's one thing that has defined his time in that office, that grand and high office, very important to our criminal justice system, it is his innumerable capacity and capability to both quibble and to be petty. But I don't want to be churlish in return. I want to be generous, at least in relation to this piece of legislation, and to say that we nevertheless support it. As the Minister correctly said, at the heart of this is ensuring that victims have information so that they can decide and they can know when it is they have their opportunity for input, because the criminal justice system is not just for the lawyers and the QCs and the highly paid and the silks. It is the people's justice. It is for people. And the overlooked part of the criminal justice system has, of course, been victims. So the first bill, the Victims' Rights Amendment Bill, ensures that victims are given information about the progress of a matter, of a trial, of a charge that is laid against an offender, so that they know when they can take their part, provide information and what have you. It creates positive obligations on the police, on the prosecutor, on other court officials, even on judges, to ensure that the victim's voice is heard, that the victims get to be interviewed so that they can prepare their victim statement, that the judge has a positive duty, having received a request from a victim to read their statement, to enable that to happen with some provisos, and the provisos are reasonable and are proper. Because we have to remember that in our justice system, in our form of justice, and it's a pity that Chris Okenvold and Cam Calder think this is a light-hearted matter where they can talk jocularly about whatever issue is that is entertaining them at the moment, but this is a serious matter for the rest of us, which is why on this side of the House we are giving it due solemnity. But, Mr Speaker, the victims must know that at an appropriate time in the disposal of a criminal matter, that they get to have their say, that a judge is required to give what they have to say due weight, and this bill provides positively for that. I was about to say that, of course, the nature of our justice system is that it is still an adversarial system. We have inherited that system, and notwithstanding what some people say about that it is no longer about getting to the truth, it is a game of jousting between lawyers, we're presided over by a judge. The reality is that the adversarial system does actually assist to get to the truth. It tests the case put by the Crown. That's the system we have inherited. And it is important in terms of the confidence of the public, the confidence of society, that the Crown assumes the mantle of prosecuting the charge, and the defendant, if they don't have the means to, or is assisted to provide their defence. But the case is put to the test, and if the following that contest of ideas and legal principle, the charge is proven, then and a conviction is entered, then the victim must be able then to have their say, and that provides some balance, a balance that we haven't hitherto had particularly well. This bill deals specifically with the situation which we have seen developing perhaps more recently, where judges have taken upon themselves to edit victim impact statements or to even prevent them from entering the court record. And so this makes a useful contribution in that regard. It also ensures that in relation to parole hearings, that the victim is kept advised of the progress and when a parole hearing may be taking place. All parole hearings are related to the particular offender. It also provides specifically for the victim, i.e. victim, to be notified about bail hearings and to have their views relayed where appropriate in a bail hearing, which hitherto had not been the case. And when it comes to young offenders, for a victim's point of view and the impact on them of the offending to be heard in a family group conference dealing with the young offender. And so these are important new developments in the framework now applying to victims' rights. Of course, the bill goes that far, but a properly developed and evolved victims' rights framework would go further. And it is disappointing that this House has spent 3 years, frankly, faffing about with this bill when actually we could have got on to something more substantial. What about a victims' rights advocate or an office of the victims' advocate? Now, the Minister has spoken publicly about a victims' commissioner. Mr. Speaker, I'm not quite sure what that is meant to add, and the Minister has not specified that. Once again, Mr. Ockenvold chortles heartily at the idea that victims might actually have an office in the justice system that would advocate for their interests and their rights. How disappointing that is from the National Party, the retiring National Party list member who hails from the West Coast. He knows better. He knows better. And I would like to hear from him about why he finds this so funny. But what about an office of the victims advocate, so that there are victims advocates in each court that victims can go to, the police can go to, the prosecutor can go to make sure that the victims tied up in a case, always against their choice, can actually understand what is going on and get their rights attended to. What about ensuring that there is a statutory right for victims to ensure that the direct costs they incur as a result of participating in the criminal justice system are met by the Crown, and that things like making sure they get a seat in the courtroom when the case that they are at the heart of is heard? Why are those things not provided for? A Minister of Justice focused on their job and not charging about having secret dinners in China would actually have got this bill passed and be focused on the real issues, which is what we need to do. Now, Mr. Speaker, as I said, we will support this bill, but we are behind the 8 ball when it comes to developing victims' rights, and the next Labor-led government will be at the forefront of ensuring there is a proper, comprehensive, cohesive set of victims' rights, that victims know where they stand, where to go, what they can expect in the criminal justice system, and it will be better than is provided for in this bill that has taken 3 years to get to this point.
Mr. Speaker.
I call Scott Simpson.
Thank you, Mr. Speaker. As Chair of the Justice and Electoral